Yes.
Adjournment request, if any, from item number 1 to 5.
May please, Your Honor.
Yes.
My lord, with consent of the other side, I beg to mention item number 4, my lord, on behalf of the respondent.
Yes.
My lord, in fact, the connected matters arising out of this.
That's right. You want time.
My lord, on 12th of August, my lord, those other connected matters are fixed, my lord, for
You want
final
it to
disposal.
You want it to be listed on 12th
12th, my lord.
as jointly prayed for. Re-notify on so and so.
Four. My lord, along with writ appeal 120/25,
Along with, take the number, rate appeal number.
deeply obliged.
Give the number to the secretary.
My lord, 120/25.
And not like that. Pass on a slip.
I'll give it in writing, my lord.
Don't depend on your memory like this.
My lord, obliged. I'll give it in writing.
Item number 2.
No one. May it please, Your Lordship. Your Lordship, with the consent of others, I beg to mention item number 1, Your Lordship. Similar matter is pending before the Honorable Supreme Court, Your Lord.
When do you want?
Your Honor.
When do you want it?
Any date, Your Honor.
Huh?
Any date, Your Honor. After
4 weeks.
oblige, Your Honor.
As prayed for on behalf of the petitioner, re-notify and so and so.
22nd. 8. Adjournment request from item number 6 to 12. From item number 13 to 25.
May I please, Your Lordship, my lord, I beg to mention item number 25 and 26, my lord. Both are related, my lord. My lord, may I pray a short accommodation, my lord?
Appointment.
My lord, my lord, my lord.
He
Professional.
wants extension, will grant it. When do you want it? 2 weeks?
2 weeks, my lord.
25 and 26?
Yes, my lord.
You are, what's your name?
A.R. Bhuya, my lord.
A.R. Bhuyan.
My lord,
As prayed for, both the items,
my lord. Oblige, my lord. I love them.
2 weeks.
11-8. 11-8.
May I please, Your Lordship? I am appearing on behalf of State of Assam Lordship. We have filed affidavit in opposition in item number 29, Lordship,
Yes.
yesterday only. So I may be allowed to call for that, Lordship.
A petitioner in person appears, no?
Yes, Lordship.
You have to inform him.
Lordship, I have filed on consent of him, Lordship. Yesterday we have served copy, Lordship.
That's right, but then let it be called out. If the person is here, we will adjourn in his
No,
presence.
no, Lordship, I am not praying for adjournment, Lordship. I am praying for call for the affidavit, Lordship, because it is not only record, because yesterday only filed.
Oh, that we will do. That we will do.
Lordship. Oblige.
Any other request?
May it please, Your Lordship. I have filed an affidavit, rejoinder affidavit in item number 42 and 43 yesterday, Your Lordship.
Yes.
That may be called for in the record, Your Lordship.
Let it be called out. We'll direct the registry and
Deeply
we'll
obliged.
post it for another date.
May it please the Lordship. Lordship, I am mentioning item number 28, Lordship. I am mentioning on behalf of the counsel for the petitioner. Lordship, can it be adjourned for this week, my lord, due to some
It
medical?
can be adjourned, but you came late, no? But you came late. 28 is over. Anyway, we are adjourning the matter. You are for whom?
I am mentioning on behalf of counsel for the petitioner, my lord.
All right. As prayed for on behalf of the petitioner, re-notify 2 weeks.
Oblige, your lordship.
May I please, Your Lordship? It's regarding item number 31. I
38.
beg to withdraw the writ appeal, my lord.
Hmm?
I beg to withdraw the writ appeal, my lord.
You want to withdraw?
My lord,
You are-
since, my lord, it is against the interim order passed by the learned,
All right. You are Mr. Fuken.
my lord.
What is your name?
Please, Fukan, my lord.
All right. Mr. PJ Fukan, learned advocate for the appellant, seeks permission to withdraw this appeal as his grievance has already been redressed. Dismissed as withdrawn.
My lord, since my lord, writ appeal is pending, my lord, I will move interlocutory application.
No, you are withdrawing the writ appeal, no?
My lord, writ appeal has been withdrawn,
And then,
my lord.
if you withdraw the writ appeal, where is the question of filing IA?
My lord, since my lord, that writ petition is still pending, my lord, it is against the interim order.
You do whatever.
Most obliged.
You don't require any permission of the court to file petitions before the writ court, no?
My lord, that
You have withdrawn an appeal against some interim order, good enough.
my lord.
ऐसे बोल लेते ना, seeks permission to withdraw the appeal, dismissed as withdrawn. Wo, as it has become infructuous. Seeks permission to withdraw this appeal, dismissed as withdrawn. Finished.
Most obliged.
I beg to mention item 37 and 38 of today's daily list. In this matter, I appear on for Hindustan Petroleum Corporation Limited lot. Earlier, Mr. B.C. Das, senior advocate, used to appear in this matter lot, but now he would not appear in it lot. So a senior would be engaged another senior lordship. Sometime may kindly be granted for that lordship.
As prayed for on behalf of respondent Hindustan Petroleum Corporation Limited and others.
They need time to engage a new lawyer. They need time to
We
engage.
don't say that. Re-notify on 3 weeks. About 3 weeks
Obliged lordship.
18-8.
or 38 में लिखना. List this case along with writ appeal number 223 of 2024. And yeah, this also, IA number so and so in
It's
W.
already there, sir. With.
Daily list orders. Item 2.
What is it for? Yes,
Lordship, this appeal was first of all dismissed, my lord, for non-prosecution, my lord, on 17-2, my lord. Thereafter, they filed one application for restoration. Accordingly, it was restored to file, my lord, on 24/6/2025.
that's all right. Now it has been restored to the original
Yes, my
file.
lord.
Let him argue.
Yes.
Yes.
As per my writ appeal, the respondents had issued a public notice dated 3rd of March 2017 to clear the dues of the industrial estate. However, earlier that notice also, I filed a writ appeal before the London Honorable Court, and the court has specified that rupees 8 lakhs till December 2016 is still remaining. As per which orders I've sent an application to the respondents to accept the amount of rupees 5 lakhs, and remaining 55,000 will be cleared as per their public notice till 31st of March 2017. However, they didn't accept the amount, and I have to file the present application before the Honorable Court. The time period during which my writ appeal or writ petition was dismissed for non-prosecution, that was a pandemic situation. During that pandemic situation, the counsel for the petitioner didn't appeared before the Honorable Court, thereby filing an affidavit that there is no contact with the petitioner, for which reason the petition was dismissed by the
What is the amount receivable from
As-
him? Just a minute.
Yes.
I'm asking him. What is the amount receivable from him as on date?
As on date, lordship will kindly come to page 91, my lord.
You tell us, then we'll come to that.
Yes,
page.
my lord, as per the direction of the learned single judge, my lord, we issued one notice, my lord, quantifying the dues of the appellant, my lord. Amount is, lordship, 89 lakhs, 68,642, my lord.
Sir, we think that you will not be able to do that. Better vacate. You'll not be able to do that. You have been paying 5 lakhs. Thereafter, you sleep over your notice, and then you say so many things. You can't remain in the premises without getting it renewed, without paying the rental.
as per their notice also, during the
Give you 1 week time to decide. If you pay by particular date, all right. Otherwise, you shall be evicted by force.
but sir,
There is a limit to tolerance, no?
yes, sir,
You can't remain in a
As-
premises
as-
without paying the rent.
as per my plea, I've said, provide me the records, and as per the orders, interim orders of the Honorable Court, I've already dispatched 25 lakhs, and from 2017,
Since you have come in a plea.
sir, I am already filing the rent as per their demand since 2017, and they are claiming 98,000. I have
Since you
filed the receipt, sir, before
since
the
you have
Honorable
come
Court.
in appeal, you deposit the amount as on date or what has been directed by the learned single judge and be done with it.
Sir, but I'm requesting the Honorable Court, kindly see, till 2017, they are saying that it was 25 lakhs I paid, and from 2017, I was regularly paying my rent. I have placed
So
the receipt.
therefore, your payment, if any, would be under protest. If it is found that this is extra, you will be refunded.
Yes, sir.
So therefore, we say that
They should be they should file the records, because since 2017, I am depositing the rent and 25 lakhs as per their own calculations I have paid to them.
take up by the impugned order dated 5/8/2024. a single judge of this court, a single judge directed the authorities of AIIDC to notice the appellant herein, calling upon him to clear the dues receivable from him. The notice was supposed to include the quantified amount receivable from the appellant till the date of issuance of such notice. By the same order, a direction was issued that the appellant thereafter would clear the dues promptly within a period of 1 month, so quantified by the AIIDC authorities. The learned single judge further directed that in the event of the appellant failing to clear his dues within the time frame prescribed, the authorities of the AIIDC would be at liberty to take steps for his eviction from the industrial unit occupied by him and for recovery of the amounts due from him under the process, through a lawful process. The contention on behalf of the appellant today is that whatever was quantified till 2017 has been paid by way of rental of the premises which he has been acquiring, which he has been occupying in the industrial unit. Thereafter, regular rental is being paid. Such statement is not supported by any receipt or any document evincing that the payments are being made. Nonetheless, we only modify the order of the learned single judge to the extent that the quantified amount under the notice must be paid by the appellant within a period of 1 month, to be counted from today, failing which the directions given by the learned single judge would remain operative. Since a dispute has been raised about the quantified amount by the authorities of AIIDC, the payment made by the appellant shall be under protest. With the aforementioned modification, the appeal stands disposed. Aforementioned modification in the order impugned, the appeal stands disposed of. Yes.
Amount of 31 January.
You please indicate, Mr. AIIDC, you please now indicate to him orally what is the quantifiable amount, what amount has been paid, he shall pay. We have extended it for 1 month more.
And it is my humble request.
And he deposits the money under protest. If it is found that the money is not to be
Quantified.
received from him, then you will have to refund.
My lord.
Yes.
Obligement.
Item number 3.
Here, I have taken step for service of notice upon the respondent number 1, my lord, through Dusty. Accordingly, I have filed the affidavit on 23rd of May, my lord.
Nobody has appeared.
No, my lord.
Notice on the respondent has been served Dusty. However, there is no report regarding service of notice. However, there is no appearance on behalf of the respondent to contest the present application for condonation or delay of 213 days. Awaiting the appearance of the respondent in the matter, the case is adjourned to 2 weeks.
Obliged, lordship.
The next one is 61 days delay.
Item number 5.
Yes,
May I please your lordship?
yes.
Appeal filed by the state, my lord, against the judgment and order passed by the learned single judge. My lord, in filing this appeal, there is a delay of 61 days. In the meantime, my lord, the respondent number 4 and 5 have.
There is a practice which I follow, that if you tell us about the merits of the case, we either condone the delay or we issue consolidated notice in the main appeal as also in the condemnation petition.
My lord.
If not, we dismiss the petition totally.
My lord.
Or we allow the condemnation petition and dismiss your appeal. Therefore, you'll have to address us on merits briefly.
My lord, now, my lord, fact remains, my lord,
over a large part and parcel of land. The writ petitioners were.
This is an appeal by state. This is an appeal by state. Yes,
My lord, a large part and parcel of land
yes.
were found to be owned by the writ petitioners by the revenue authorities. Under the statute, that is the Sealing Act of 1956, the maximum permissible limit is 50 bighas per person. The authorities found way back in the year 1976 that these writ petitioners, or for that matter, the predecessor in interest of the writ petitioners.
All right. All right. Do you object to condonation of delay?
Condonation, not really, my lord, but admission.
That we will hear. For the reasons we have heard, Sri,
My lord, R. Borpuzari. R. Borpuzari.
R. Bhatt Pujari and Mr.
BT Deccan.
So and so. For the reason, this is an application seeking condonation of delay
61 days.
of 61 days in preferring the appeal. For the reasons stated in the application, the delay is condoned, the application stands allowed. List the appeal under the appropriate heading on. We give a date.
Right.
When? 2 weeks?
My lord.
Obliged.
And so obliged.
13/8.
Next is.
Item 6.
Item 6.
Yes.
May I please, your lordship?
265 days.
Lordship.
And what is the matter?
Lordship, the matter is regarding the service contract which has been
Let's see,
done by the.
the order of Sestat or Sestat, no? August.
Sestat order, Lordship.
There has been an addition of what amount? There has been an addition of what amount by the department? I would expect the learned
Lordship.
counsels to be ready on basic facts before addressing.
My lord, may I submit?
That's his case, his turn.
So it's 6 crore 39 lakhs 9,190, Lordship.
And you have not followed the instructions issued by CBIC, the SOP.
So that has been duly followed, Lordship. We have prepared the central excise office and the condonation is of 265 days and notice was.
Condonation is all right. We
Lordship, they have-
condone only when we find there is a merit in the case.
Lordship, they have filed
If I
their,
have merit in the case, we'll condone the delay, we'll hear.
Lordship, they have filed their written objection against the notice issued in the IA for condoning the delay, and they have made certain allegations against the department. So we need to file reply against the objection, Lordship. That has to be done, Lordship. The reply has to be made, Lord.
The department doesn't have a case, it appears prima facie. Pre-show cause notices consultation. That's a must.
So I may be given 2 weeks time to file my reply against the written objection, Lordship. Will clarify the condemnation of delay of 265, Lordship.
Well, the practice here is good delay, no? Anyway, we condone the delay, fix it for hearing.
No, my lord, may
from
kindly
my
record my objections. My lord, may kindly record my.
You have said that the government latches delay, that's not a ground. We don't accept it. You don't fight the other side with the hands tied back.
My lord, my only submission.
Where is the question, Mr. Counsel? You don't understand which side the wind is blowing. We are not finding fault with, we are not finding fault with the order passed by the Sestat.
My lord.
Therefore, even if it is condoned, does it bother you?
No, my lord,
Then,
not really.
I
But my lord,
understand.
may kindly record my submission. Sir.
Don't
That's all.
unnecessarily, we will record your.
My lord, my lord.
Take it. We have heard Sri
Agent.
and so and so
Yes, Mitra.
on the issue of condonation of delay of how many days? Of so many days in preferring this appeal against the order passed by Sestat. First of all, the respondent has seriously opposed the condonation of delay on the ground that the only reason assigned in the application is the governmental delay in preferring the appeal. Even otherwise, the land counsel for the respondent submits that that there was no pre-show cause notice consultation, which is mandatory before saddling a party with taxes under the category of works contract, taxes for works contract services, which in the case of the respondent is non-existent, as the work contract services offered for government organization is exempt from taxation. However, for the reasons stated in the application, the prayer for condonation of delay is allowed. The delay is condoned, the application stands allowed to the extent indicated above. List this appeal under the appropriate heading on, give a date after 3 weeks.
Grateful, Your Honor.
Madam, they may kindly supply a copy of the appeal,
Not obliged, my lord. Much obliged.
28. Item number 7.
Wait, please, my lords. 95 days delay. Family pension matter. The apparent is the first one.
The appeal is the first.
The red petitioner is the red petitioner respondent now is the daughter of the second wife. So the single judge has said that there should be proportionate family pension given. And the 1969, it's not very clear. It's not as per the CCS rule.
Amended provision of rule 143.
Yes.
We will hear.
Yes.
in the appeal memo page, my lord, it is in appeal
That's
memo.
right. We are, prima facie, we are in agreement with the judgment, but let it be contested.
My lord,
can know the delay.
delay may be condoned.
Take it. For the reasons stated in the application, the delay, जैसे लिखा है वैसे करता है, delay condoned, the application stands allowed. With this matter also. After 2 weeks. Now,
My lord, only.
you're the stepmother, no? You are the stepmother.
lord, I am the first wife.
I am the stepmother's daughter.
Acha.
My lord, only my prayer is this, my lord. Though there is no stay order, in the meantime, the respondent hearing,
There's
my lord, here, because she is in need of money
that's right.
because of the process.
So there is no scope of any
Well,
such direction in this application.
My lord, what has happened now, my lord, because of this, they are not, the department is not in the doing the process.
They can't know. They'll fall in contempt. The order is very clear.
No, my lord,
That the process should be initiated and whatever is recommended to the Accountant General's
but
Department.
that my grievance is the process has been stalled because
No,
of the filing of the writ appeal.
We keep only 2 weeks.
Because-
Come again, we'll tell. This is not the forum in which such direction can be issued.
No, but my prayer was that it could have been preponed before 2 weeks. Then, my lord, I could,
1 week,
1 week, that much my prayer is.
give a date.
1/8. First of August.
Okay.
Item 8 and 9.
The sun is what? I think it's a great example. So there is a problem. On the day you'll be surprised. One gentleman's reserve. So for that, I'll have to.
Basically,
May it please the Lord.
Very easily, I will not leave you. Yes,
May it please the Lord.
this is item number?
Item number 8, my lord.
Yes.
My lord, we have filed this IA
Hmm.
because that page number 20, this letter was issued by the authority during the pendency of the case, my lord.
Page number 20.
20.
Yes.
As instructed by the Director of Secondary Education, Kahili Paravite, labor details so and so, it has been observed that many schools which are not affiliated to SEBA and do not have UDI's code have registered their students in class 9 through government provincial schools or other affiliated private schools. But such students are not actual students of the school where they are registered and can be termed as fake student of registering school. Such activities have created problem in monitoring the performance of the government provincialized schools. In this connection, all head of the government and provincialized secondary schools are hereby instructed not to register any outside students who are not studying in the schools. Our predicament is, my lord, we are all private unaided schools. Now, under the existing procedure, my lord, our students appear in exam through some existing provincialized schools, my lord. Now, I can appreciate on merit, but there is an order of this honorable court, my lord, which your lordships will get at page 24. So I think that parity should be maintained till this matter is disposed of.
24, what is it?
24, my lord.
Yes.
Earlier, there
This
was
is
a
a different matter.
No, in the other item, item 9. Item 9.
Okay. But with respect to schools, unaided private schools.
Same cause of action, same grievance.
This is all Assam English medium schools.
Yes, again, private unaided.
What is the interim order? Let's see.
Now, yes, Mila. Now, earlier there was a status quo, and this was modified that way at the prayer of the government, Mila. Please come to the first subpara. Departmental lawyer submits that there is a presumption on constitutionality of statutory enactment, and therefore, although the virus of the Assam So-and-so Act is under challenge, the court should allow registration of private institutions since the relevant database of the non-government school is necessary for several other official purposes. Thus, respondents pray for clarification of the status quo order passed by this court on 15/10/15 to facilitate collection of data from the private school without insisting on their registration at this
So
stage.
this is the catch here, no?
Yes.
So therefore. this
Without
order-
insisting on their
Parity.
registration.
Without going any further, we give you the parity to this extent. No registration.
No.
Your student shall not be registered.
No, my lord.
Then,
Without registration, my lord, we cannot appear in the HSLC.
no, that's
exam.
right, but they facilitate, so they,
Without insisting on registration means, my lord,
without registration of the school.
yes, under the act.
Under the act.
Act. Lord, act envisages that their school must have a particular extent of plot of land, etc., etc. But basically, my lord, the land issue is coming in the way. And in the statute, there is a provision where we may like to eventually go.
Now,
But
is
for
there
the
any-
present, my lord, I'll
Is there any impending examination now? Public examination for class 9, class 10? See, the purpose is very good.
yes.
You know, normally the standard of education goes when this kind of arrangement is permitted.
Correct.
Now, we do not know, the students don't attend classes in private schools, unaided schools, schools which charge a lesser fee. They just get enrolled so that they can do any other thing and have the degree. This is the practice, not very unusual for
That's a national phenomenon. my
national
lord.
phenomena. I can talk about 2 states. The Assam is no exception.
And we
But then if-
bordering state. my lord.
But you see, if the government is trying to enforce it,
My lord, I'm not with that. All that I'm saying is, my lord, till the finally matter is disposed of.
and if it is found that you're not a student, your degree is
That's
not.
that those actions can be taken, my lord. That they will. My lord, in fact, the private schools are performing much better, my lord.
No, private school of substance, private school where
Well, these
they
are all-
don't want any
These
aid.
are more or less. my
These
lord,
are schools where they charge 300 rupees annually. That's only for the purposes of running an institution, having a support base, and then facilitating students to carry out their other vocation in life and then get a degree ultimately. We know all this, no? But then the difficulty is that your petition is directed towards, declaring section 6 of the.
No, that
Act
is, that is on
2006.
the merits of the case, my lord,
That's
that,
true.
that will flash out at the time of hearing, my lord. For the present, all the time saying is, my lord, similar orders should govern and they will not insist upon that 19-4 order, my lord. End of the day, my lord, if the students cannot enroll in class 9 and they are not permitted to appear in the HSLC exam, then my lord, it will have a serious impact. We are not, I mean, for a moment even questioning the wisdom of the government, my lord. They are trying to.
Take.
My lord, just
Yes.
that one thing.
Yes, Mr.
My lord, page 18 of the IA itself.
Yes.
This was issued by the Board of Secondary Education Assam on 28th of March 2024.
Yes.
Where simply says that if the school is not registered under the UDAS data, if does not have a data, the student will not be allowed to be registered under a government school or a provincialized school if he is not a student of that school. The interim order which has been passed or which has been pointed out
Page
speaks
24.
about, page 24 speaks about the registration of the school under the act. Here the issue is about the
That
registration.
result is the same.
No,
There should not be any insistence for the school's registration with the CBSE.
School's registration under the Act of 2006.
How do we allow people, how do we allow students of English medium school to get, to write the ninth-
Registration under the government or provincialized schools where they are not even studying. They are trying to appear in examination, a public examination, not being students of the government schools.
No, how do you say so?
Well, that is their stand.
No, there are 26 schools.
Yes, they are all
This
private.
is an
schools,
association of 26 private
26
schools.
private
Now,
schools.
do you have the database? Do you have sufficient facts with you? I mean, we are looking at students' career for the
Yes.
moment.
We are not,
We appreciate your
SEBA
efforts.
is not a party here.
Mr.
SEBA has not been.
Mr. Mazumdar, we are appreciating the efforts of the Education Department, CBA, the Assam Board, all right. But then suppose there could be instances where students would not get admitted to government school. They study in unaided school and ultimately they pass the public board examination. Have you said that no such proxy exam, not proxy, no such private school student can write public examination?
Public examinations, they can appear as private students, but not as students of the government's provincialized schools. Why should they appear as students of the government or provincialized schools when they are not with us? SEBA's letter, if lordship sees,
No.
point number 2.
What about this interim order?
The interim order requires private schools to run. They will have a UDAS because the UDAS shows their existence. Registration under the act of the school itself is kept in abeyance. They need not, the schools need not register, but their students can register with the SEBA. The registration which was stayed,
SEBA is what?
the Board of Secondary Education,
Board of
the registration which was stayed was the registration with the government, not with the SEBA. The SEBA registration, the registration of students with the SEBA is a different aspect. It is not with regard to the.
Can they appear in the examination or not?
They can appear as private students. They appear. They apply. They appear. That is what the Board of Secondary Education can clarify. They are not a party in this IA or the repetition. How the Board of Secondary Education would like them to appear is what the Board of Secondary
I would
Education.
say that they will be allowed to appear as a private student.
But the Board of Secondary Education has the system.
Yes, Mr. Chaudhary.
Why appear as students of government schools?
We would have allowed it only if we were satisfied that
My lord, on that, my lord, to be honest, I'm not very clear on that
just
aspect.
find out, or we allow you to add the
My learned friend's submission may be recorded and we'll approach the board, my lord.
we dispose it of it.
Yes, private is there, but allowing a student who we do not know from which school.
If you're sure that they can appear in the public examination, the students, these teachers, as a private student.
Yes.
And you'll not insist for
My friend from the
USID.
SEBA, who represents the SEBA, is here, my lord. He can have the instructions on that, but allowing.
Can you tell us what is the mechanism?
Government
How
school
would
will
a
be
student
different.
Party, no.
Now, if we record your submission, would it be all right?
I have not been submitted, but furnish any copy of.
Yeah.
My lord, may I pray, my lord, we'll also have the instruction. Could it come up on Friday if it is not inconvenient? We'll also have the instruction. my lord.
All as prayed for on behalf of the appellant applicant re-notify on Friday.
25/7.
Publication.
Item 10.
13 days, 1 week.
Who appears? For the reasons stated, the delay is condoned, but nobody has been appeared. This 13 days, you're not contesting.
Lordship's judgment, my
Oh,
lord.
my judgment.
Condonation or delay, what happens?
That could be that.
You'll not be hearing it up.
No difficulty. I just figured it out.
For the reasons stated in the application, the delay is condoned. The application stands allowed. Nobody appears, but you would have been here. Let's see, we'll see it on that date.
Obliged.
List after the, under the appropriate heading, 3 weeks.
18. 18. Item 11.
May it please the lordship.
Yes.
My lord, before referring to documents.
No, what have you come here for?
My lord, may I summarize in 5 minutes, then it would be.
Plus the prayer, then
My prayer is-
summarize.
My prayer is, my lord, to state the further proceeding in respect of vesting order.
In respect of?
Vesting order
Vesting
given to, order given to respondent number 3. But before that, my lord, for better understanding, my lord, let me, my lord, place synopsis of the matter, your lordship. My lord, for the purpose of mining and sale of, my lord, Namchik West Coal Mine in Chirang district of Arunachal Pradesh, my lord, a tender was floated, your lordship. I being eligible for participating in the tender, your lordship, I participated in a tender. I furnished bank guarantee of 2 crore, everything I
Right.
had.
You were disqualified.
I was
technically.
disqualified without assigning any reason why I have been disqualified.
And you challenged.
I approached this honorable court before learned single judge, my lord. Learned single judge was pleased to issue notice, and as an interim, my lord, learned single judge directed that tender process may continue, but finalization cannot be done without leave of the court. Against that order, my lord, respondent number 3 approached, my lord, division bench. And division bench has passed very interesting order that I will place, my lord. Interesting order saying that since the learned single judge has not assigned any reason in passing the interim order, finalization can be done without leave of the court. But the finalization shall be subject to outcome of the writ petition.
Absolutely stayed order, not interesting, but stayed. This is the order which should be passed.
I don't think, my lord, I will place, my lord, this order,
We have
my
been
lord.
passing
It is
such
like
orders.
that, my lord, in the lighter side.
We don't forestall
My
the
lord,
proceeding.
in the lighter side, if your lordship permit me, divorce
No.
petition is pending.
Lighter side is permitted only to the court.
My
To
lord,
be on the
My lord.
serious side.
I'm serious side also, my lord.
Yes.
Divorce petition is pending. You are allowed to remarry, but
the-
your remarriage shall be subject to outcome of the
Mr. Counsel,
divorce
your
petition.
example is absolutely inapt. It is not even interesting.
Example
this
is not
is-
interesting, but
Example is
it
not
matches with
interesting,
the,
it is not apt, but it does.
my lord, it matches with the situation, your lordship.
Sorry, you be serious in your submissions. No comparisons.
My lord. So what I am submitting, your lordship, thereafter, that writ appellate court has disposed of that interim order. And in the meantime, my lord, they started, my lord, to issue vesting order. My lord, I will place, my lord, documents. I will satisfy your
No
lordship.
document is required. This is the order which is required to be passed. We can't forestall the process. If at all it is found
My
that
lord.
you were wrongly, non-suited on the technical ground.
My lord,
And thereafter.
I am offering, my lord,
The hands of the-
521
the
crores.
clock-
My lord, I am offering 521 crores more, your lordship.
See, that is.
Or why I have been rejected technically, my lord. There has to be some reason, my lord.
Naturally.
In the writ petition, my lord.
Therefore, it has been made subject to the outcome of this.
My lord, but
writ petition.
thing has to be remain, my lord. By that time, they will start.
You can ask for an early hearing of the case.
My lord, but they have not filed affidavit till today. My lord, matter is fixed on 4th of August. Before learned single judge. But till today, they have not filed any affidavit, my lord. And regarding, my lord, I have given, my lord, that I am ready to.
Let us see the single judge's order and the
My
division
lord,
bench.
my lord, my lord. That your lordship will find that page.
Thirty-seven.
Just a minute, Mr. Counsel.
My lord.
Why it did not struck me immediately? The impugned order is of the division bench, no?
No, single bench. I am seeking single bench. My lord has not passed the order because of the division bench. So I am challenging the learned single judge order, your lordship.
Let's see the single judges. Sir.
Impugned judgment, my lord, will see at page, my lord, in the writ appeal, your lordship, page 231.
231 writ appeal.
In the writ appeal, my lord.
Then what is this order dated 2/4/2025?
2/4 what division bench preferred by my lord, respondent number 3, where this honorable court allowed to finalize the tender without leave of the court.
So therefore, you basically want vacation of this order, no?
Modification, my lord, because learned single judge hands were tied because of this order, your lord.
This order before superior forum.
My lord, before.
It's a bench of coeval strength. I forgot because in Patna we have originally it goes before the division bench.
My lord,
I thought it's the division bench.
What I am submitting, your lordship, always we are coming before your lordship for modification. And that order was passed interim. That was not final order, my lord.
Therefore, the modification, it has to go before the same bench. The bench has to be constituted.
Hello, that's modification also, my lord Justice Nair recused it.
I have filed this application, IEA, modification. Where is it? Let's see what is your prayer. Modifications of the orders dated. You go before the same bench. That
My
bench
lord,
will be constituted.
that same bench recuses, my lord. Justice, my lord Justice Nair recuses from taking up the matter.
The senior judge would be there.
My lord recuses because in the second.
One of the judges who has passed the judgment or the order.
2 orders, my lord, 2 orders.
So this modification goes there. Take it.
The bench is, my lord, my lord Justice Surana is sitting in next week in my lord Itanagar, your lordship.
Who tells you all this? Who tells you all this? Do you make the roster?
No, my lord, I am told that at the bar, your
Who
lord.
tells you all this?
At the bar, my lord, it was there, your lord.
Bar doesn't make the roster. Mr. Counsel, you are, I mean,
at the bar,
every third line you're crossing your limits, no?
The list.
No, not crossing, my lord. It was their rumor, that's why
You talk about rumor in the court.
my lord,
Who
I
tells you all this?
apologize, my lord. I
Yes.
apologize.
I mean, we accept your apology, but then don't make such statements.
My lord, I apologize. My lord.
Take it up. The applicant seeks modification of the order dated 2/4/2025, passed by a division bench of this court.
Two 4 and 2/6, your lordship, 2 orders.
2 orders.
Seeks modification of the orders dated 2/4/2025.
27 and 29. No. 27 and
2/6/2025.
where is the page?
Page in IAT, page 34, my lord.
And 2/6/2025. This order, but why is he asking for modification of this order? Inside. Come to the order dated 2/6/2025.
My lord.
Yeah.
Page 34, my lord.
Yes. Page 34, read it.
Page 35, your lordship, may kindly come. It is para 7, your lordship. It is worthwhile to mention here that para 6 of the order 2/4, my lord. So read as under. It was quoted, your lordship. Thereafter, in
Just
view,
read that, no?
my lord, having noticed that no regions have been assigned in the order dated so and so, passed in petition number so and so, as to why the tender process should not be finalized without the leave of the court, and that the court has not recorded its prima facie satisfaction with the entitlement of the petitioner for granting interim relief. This court is inclined to stay the operation of the interim order dated so and so, passed in writ petition number so and so. Accordingly, there shall be no bar for the authorities to finalize the tender process without the leave of the court. However, the stay is made conditional by providing that the finalization of the tender process shall be subject to outcome of the writ petition. The stay is also on the condition that the applicant shall file an undertaking in the form of an affidavit within a week from the date of this order before this court abide by that whatever direction that the court may pass in the connected writ appeal as the finalization of the tender process is made subject to the outcome of the writ petition. In view of the above order dated so and so, in so and so, nothing survive in the appeal. Accordingly, taking note of the submissions of learned counsel for both the parties and also considering the facts and circumstances on record, this court is inclined to close this appeal. Now the learned single judge may proceed to hear writ petition so and so. However, till disposal of the writ petition, the interim stay granted by order so and so, and the condition therein that finalization of tender process shall be subject to outcome of the writ petition shall continue as provided in para 6 of the order dated so and so in IA number so and so arising out of the present writ appeal. Page 37 is the
You need a modification of the order dated 2/6/2024.
2/4 and 2/6 both.
No, 2/4 is not required, no?
2/6, my lord.
2/6 only.
Imping order is at page 37, my lord.
Can
we modify?
No, we can't. He's chosen a wrong forum. I don't know. He should have, the appeal was dismissed, but why this? Why with this? Why was this? No, we are slightly wary of this.
This is also actually, it is contradictory.
Give us the order passed with single judge. That's the page in
Page
the
37, my lord.
page 37.
In the IA.
They're in your eye of the
Aye.
last page.
Much it is there.
Last. Thirty-seven.
Against the order dated 23/6/2025, you came in appeal.
My lord.
And in the appeal, the matter was decided on 2/4/2025.
No, my lord.
23
Against this
6 has been
present
made on the basis of the division bench.
No, just a minute. So this was kept pending.
2/4, my lord.
If
Referred by
notice returnable, 2/4 notices were issued.
2/4 was prepared by my lord, respondent number 3 of appeal. Successful bidder.
Successful. All right. All right. Pursuant to the NIT, this was pursuant to the NIT.
NIT. Dated,
NIT, you had applied,
I applied.
all right? Complete it here.
NIT dated 5/12/2024.
You had applied, you were technically non-suited,
No,
on which date?
that is of the 13 March 2025.
13th of March 2025, all right. Then you filed an application,
Writ petition.
writ petition. What happened?
On 17th, this honorable court was pleased to issue notice. And as an interim, it was directed that they can proceed with the tender, but finalization shall be done only with the leave of the court. Against that, respondent on 3 approach file writ appeal. In writ appeal, learned honorable division bench has stayed the interim order and pass an order said that the leave of the court is not required. They can proceed, but finalization shall be subject to outcome of writ petition.
Now we are dismissing this petition. We are not even permitting you to go there. Take down. The third, Mr.
A. Goyal, my lord.
Mr. Goel, learned advocate for the appellant, for the applicant. At the threshold, we are not inclined to interfere. Therefore, there is no necessity of any other person. Lego, third, Mr. Goel, learned advocate for the applicant, who seeks a modification of the order dated 2/6/2025. Passed in so and so. Passed in WA 17 of 2025. The records reveal that against notice inviting tender for mining rights, the applicant had applied but was technically non-suited, though without assigning any reason whatsoever. This was challenged by the applicant in a writ petition where notices were issued to the parties except the successful bidder who was allotted the work in the aforesaid writ petition, an interim order was passed directing that the process of finalization of tender should continue, but the final result would be declared only with the leave of the court. Sensing that this order would have caused delay in finalization of the tender process, respondent number 3 herein, the successful bidder, challenged the aforenoted interim order before this court.
Page 22. Para 6. Page 24.
The division bench, by the order dated 2/4/2025, found that no reasons had been assigned in the order passed in the writ petition as to why the tender process should not be finalized without the leave of the court. It was also observed by the division bench that the writ court had not recorded its prima facie satisfaction with the entitlement of the applicant for granting interim relief. Thus, the division bench modified the order to the extent that the authorities would finalize the tender process without the leave of the court, but the finalization of the process shall be subject to the outcome of the writ petition. There was a further caveat in the order passed by the division bench that for such conditional finalization of the tender, the applicant shall file an undertaking in the form of an affidavit within a week from the date of the order before the court. For the-
Next order is at page 27.
Thereafter,
No, the next order.
next order is
Page 36. 35, 36.
Interim order, Your Honor. There's 37 single bench order. Interim.
No, before that, there's a different page.
thereafter. White order dated 2/6/2025. The division bench was of the view that there was no necessity of continuing with the appeal, as in sum and substance, the cause of the applicant herein remained protected. Stop. If it was ultimately found that the technical non-suiting of the that the applicants if it was ultimately found that the applicant was wrongly non-suited on technical grounds, the hands of the clock could always be turned back, and the final process could be questioned. So in that view of the matter, it was observed by the order dated 2/4/26/2025 that the writ court would continue to hear the appeal, meaning thereby that the authorities would have a free hand in disposing or in concluding the tender process. But the final result would be subject to the outcome of the writ petition. The learned counsel for the applicant seeks a modification of this order with what intent is not understandable to us. If such protection has been given to him by the division bench, that the final decision of the authorities shall be subject to the decision of the writ court, the applicant has received that protection on the judicial side. The prayer made on behalf of the applicant for modification of the order is absolutely unmerited and is dismissed.
Deeply.
Item number 12 and 13.
Yes.
Maybe. This case is filed for, my lord, saying for grant of status quo, my lord, in respect of the promotion to the post of headmaster in LP school, my lord. But in the meantime, my lord, the honorable single bench has already passed a similar order, my lord, in a different case filed by a group of candidates.
What has happened? I couldn't hear you.
My lord, this case is filed, my lord, only for granting a status quo in respect of the appellant's my lord, post where they are serving as in charge headmaster, come the assistant teacher of this.
This happened, what state, which order is required to be a state? Which position? I mean, you'll have to say something.
Yes, lordship. The
Who are
process,
who are these petitioners?
they are the contextual teachers serving under the department of.
The IA has been filed in an appeal.
Yes, lordship.
This IA has been filed in an appeal.
Appeal.
Let's see the order of the single judge.
Yes, it's not there, my lord. It is passed subsequently, so I'm placing your lordship. It's not
Put
there.
it on record.
After
It's on the main, it's in the main file.
not, my lord. After filing of this case, this.
Put it on record. We don't accept documents like that.
This is not an appeal, madam. This is a writ petition challenging the virus. He has challenged some
Yes,
virus.
challenge the virus of what?
Yes, it's a WPC, if I'm not.
It's a, my lord.
It's an appeal.
Yes, In this case, sorry, my lord, it's a WPC, my lord,
Like, WPC like.
we have put to challenge, my lord, the Assam Elementary Education Provincialization Fourth Amendment Rule 2024, my lord.
Page 91, no.
No. Challenge made to the Assam Elementary Education Provincialization SOP for promotion and for regularization of services of consulting compared with the question debating when in the role of the local service. No, but why stay?
Well, Miss Case is fault, but in the meantime, the department has initiated a process to promote the assistant teachers of LP school to the post of headmaster in the schools where the number of students is more than 150, not in all schools, my lord. And we are some of the petitioners, my lord, they are serving in those schools as in charge headmaster of the school, my lord. And the issue in this case, my lord, that the process whichever they have adopted through this impugned rule, my lord, that has
Has this writ petition been ever heard?
this is notice issued, they have not responded yet. It my writ petition, my lord.
Yes, Mr. Mazumdar.
There are two writ petitions connected. In the second writ petition, we have filed our affidavit.
That will not cover our case, my lord.
Anyway, file your affidavit
I'll
here
file my
also.
affidavit only.
And you file a consolidated affidavit for the stay and not. Okay, let consolidated affidavit be filed by the respondent number
1 to 6.
Hmm?
1 to 6.
1 to 6. In the IA
I'm
number.
sorry, my lord,
so-
4 to 6.
4 to 6.
4 to
In
6.
IA number so and so, and in the main writ petition by the next day, 3 weeks.
Obliged.
Obliged.
20, 28. Item 14.
Madam, I am appearing for the KB, respondent number 1. There is a delay of 41 days, madam, in this too.
You are very generous. You want it to be condoned.
That I am not on that, madam. Merit, there is not already everything over, madam.
What is over?
Interview over, everything over, selection.
Let's see. So we condone the delay. We'll hear it when the petitioner comes. Nobody appears on behalf of the applicant who seeks condonation of delay of so many days in preferring the appeal.
41 days.
41 days. The land counsel for respondent number 4, however, is present. He does not oppose the condonation of delay of 41 days. For the reasons stated in the application, the prayer is allowed, the delay is condoned, the
IAF.
the IA is disposed of, the appeal be listed under the appropriate heading on your.
So there is another appeal, there is another IA for leave to appeal.
No leave is required.
Number has not been yet. Appeal
There
has
is
not
this
registered.
2248
Yes, no, 2248 is IA, madam.
for leave to appeal.
No, condonation.
Condonation.
No.
Oh,
Appeal is a.
oh, yes, madam.
It's leave to appeal, that's what is.
Number 9 is.
A leave granted.
Yeah.
Appeal to ही नहीं है इसका. No. Just a minute, appeal has not been filed, no?
2249.
Appeal is filed,
Appeal has-
this has to be registered now.
Leave granted, appeal should be registered. अब उसमें वो मत लिखना कि let this delay condone. Just.
Leave also, madam, 2249. So for leave is concerned, IA, 2 IA, madam.
Do I? That's all right.
Obliged.
Item 15.
Order check up.
Yeah.
Just check up this order. It's a-
Lordship, 15 may create a matter and pass on for a time being, your lordship.
No affidavit has been received from the respondents till now.
Out here, basically challenging the simultaneous holding of the departmental proceeding and the criminal proceeding.
For some time, your lordship.
Yes, Rajya is long gone. You want time?
After some time, your lordship.
After some time means Passover.
Passover, lord.
No, tomorrow.
Okay.
Apply.
Item 16 for admission.
Dismissal from service.
Yes.
May I please your lordship?
Security of. Yes,
May I please your lordship?
yeah,
Lordship, I am appearing on behalf of Tishwam lordship. Today some difficulties. Kindly give 1 week time lordship.
Adjourn for 1 week. He's bringing for them.
all right. You have no objection?
No, lordship.
Is a dismissed employee.
Lordship already charge-sheeted, lordship. Charge-sheet has been filed quite as soon as possible.
Charge sheet is something else, no?
Lordship.
Dismissed employee, he was a PSO. And he left the place where he should have been and somebody was murdered.
Yes, Lord.
Let's see after a week. You will appear. You will appear in the matter.
No, lordship, my senior. will appear.
All right. As prayed for on behalf of the appellant, re-notify.
1-8.
Okay, lordship.
Item 17.
After constable dismiss. Taking bribe of 2,000. Mr. Chaudhary.
Medical Lordship, my lord. Dismissal from service a constable, my lord. He had taken 2,000 rupees, my lord, in order to clear a bill, my lord. This is the allegation, my lord. I am only on the disproportionate part. I am not, my lord, on other, my lord. I beg to you, my lord, a constable of 29 years service, nothing, no.
Difficulty,
H.R.A. Chaudhary.
Mr. Chaudhary, the difficulty is this, that proportionality was brought in service jurisprudence only very late. Right? Ranjit Thakur's case, but they say that if it is absolutely shocking to the judicial conscience, you are a police officer.
No.
You are accepting bribe. 2,000 rupees was found in your pocket. Your hands were turned the liquid where it was paid.
I am absolutely with lordship, my lord. I am absolutely with lordship, my lord. My only question is anything else than my lord that whether it can be,
discussed, no?
my lord, only thing, my lord, your lordship discussed. My only 29 years of service and of 6 years remains, my lord, in today, my lord. And only, my lord, it can be converted to, there are provisions, my lord, that can do it, my lord.
Let us see.
Page around 19 of the judgment.
Yeah. Implemented is, my lord, your lordship. Yes. Page 86. One 47.
You would be governed by which rules?
My
The
lord,
departmental proceeding against the officer would be governed by, against this constable would be governed by which rules?
that, my lord, your lordship, Assam police manual, my lord, for free.
Does the provision say anything that witnesses have to be examined? Or only on the inquiry report it could be concluded? You have to argue like this for talking about proportionality. Understand?
18.
My lord, once if I am married, certainly that will come, my lord, because your lordship on the face of it, my lord.
No evidence was settled, no?
Rule line. Nine.
You have not raised that objection. Does the police manual, Assam police manual say that there is a necessity
No,
of,
two rules are applicable. One is
how many
Assam's
witnesses were examined in
My
the
lord.
departmental proceedings?
6, madam.
So 6 were examined.
6
You
is,
got
I
an
mean,
opportunity to
and
cross-examine them.
your lordship, kindly say page 19, just have a look, page 19, ma'am.
Page
Page 19 in my repetition, ma'am.
in your writ petition.
Yeah. Madam, page 18 bottom, Lana Singh has failed to appreciate the conduct of the inquiry proceeding, your lordship. Proceeding initiated against the applicant suffered from various procedural lapses, etc.
What procedural lapse?
No, that your lordship, such as the evidence of PW1, PW2, and PW6 were recorded in absence of the applicant.
So you would not have been there.
Yes.
You would have been supplied with a copy of their statements. Did you raise an objection before the inquiry officer?
No, that was my.
In your absence, so
Yes.
therefore you came to know about it later.
My
Did you
lord,
raise an objection?
a constable, my lord, your lordship is very much a constable, my lord, how he can.
Proportionality in
And
this
these
case-
are given in the state, my lord, specific evidence here.
Resisted to trap. There could be cases where there is forcible, trap. But then here he himself was a constable. He was asking for 10,000 rupees. He could get only 2,000 rupees.
But I am simply, my lord, this thing of things, my lord, he is not aware of this thing.
Heard Mr. Chaudhary led an advocate for the appellant and so and so for the state.
As per one.
The challenge in the aforementioned appeal is against the judgment dated 11/12/2024 passed by a learned single judge of this court who did not interfere with the order of dismissal of the appellant. It appears that the appellant was trapped. The appellant was, in a trap caught in flagrant delicto accepting bribe money. A criminal case also was lodged against him. Stop later. In the disciplinary inquiry initiated, he was charge sheeted. And the inquiry officer examined witnesses on behalf of the prosecution. The appellant challenges, the appellant raised a grievance that 3 of the witnesses were examined in the absence of the appellant. However, no objection was raised with respect to that during the entire departmental proceeding. The inquiry officer concluded that the evidence was absolutely cogent so far as the culpability of the appellant was concerned. A second show cause notice also was issued to the appellant, to which he had replied, but the reply was not found to be satisfactory. Hence, he was subjected to a punishment of dismissal. The appeal against the aforenoted punishment also could not succeed. The learned single judge considered the questions raised before him, including the issue of proportionality of the judgment to the offense committed. A reasoning has been given by the learned single judge, which is quite in consonance with the law in that regard. It is only when the punishment is found by a court to be outrageously disproportionate to the nature of the allegations leveled against the delinquent, then only the principle of proportionality would come into play. a decision by a disciplinary authority could be questioned on grounds of procedural impropriety, illegality, or perhaps irrationality, but only when irrationality, see, the principle of proportionality was introduced in the service jurisprudence very late, especially with the question of the choice of quantum of punishment being questionable. True it is that the choice of quantum of punishment is within the domain of the disciplinary authority, but it cannot be gainsaid that any punishment would suffice. Stop. It must suit the offense and the offender. If the sentence is unduly harsh or vindictive or so disproportionate that it would shock the conscience of the judicial authority, it would be akin to a kind of evidence of bias. In the present case, the learned single judge was absolutely justified in holding that the sentence imposed, that the punishment imposed, not sentence, punishment imposed on the appellant was justified for primarily the reason of the appellant being in police force. And secondly, all evidence against him of having accepted the bribe money. We do not find any reason to interfere with the judgment of the learned single judge. Thus, we dismiss the appeal, but make it cost easy.
Obliged.
Item 18.
May it please, your lordship.
Yes.
This is a writ appeal against the order passed by the Honorable Single Judge. But what happened in this matter, the appellant before your lordships, he graduated from the Delhi University and he appeared in the Combined Competitive Examination 2022 held by the Assam Public Service Commission in the state of Assam. My lord, admit card were issued to him. Admit card was issued to him giving a roll number. He cleared the preliminary examination. Preliminary examination was for screening only. It do not count for merit. Now he cleared the preliminary examination. Thereafter, my lord, he cleared the viva also. Viva comprises of 6 papers.
No, after preliminary examination, there was no written examination.
After preliminary examination, sorry, my lord, I'm sorry. After preliminary examination, mains examination was held.
That's right.
I'm sorry, my lord. Mains examination was held, which contains 6 papers. My lord, mains also cleared. He was called for interview. He appeared in the interview, my lord. Thereafter, the notification was published declaring the result.
And your name was not there.
My name was not there. Then he filed an RTI application.
He filed what application?
RTI application, seeking the information as to why his name was not there. The APSA authorities furnished information saying that he wrote his roll number in the QCA booklet for question answer booklet for General Studies paper 3 wrongly.
There are two issues, my lord. One is, my lord, I am seriously disputing that the handwriting written in the question booklet, even if by bare eyes, it can be. Yes. I'm sorry, my lord.
No, no, please, but
Even if with bare eyes, it can be, my lord, determined that that those handwritings were not mine. That is one aspect of the matter. Now, the learned single judge, my lord, derive one conclusion that roll number is the only source of connecting the question booklet with the candidate. I have that, my problem is there. Because if I take your lordships with the question booklet, because there is no iota of doubt that I did not appear in the GS3 paper. Because in the attendance sheet, my signature was there. The APSC also not disputing that I did not appear in the GS3 paper. I appeared in the GS3 paper. And each question booklet is given a definite number. My question booklet has had a particular number, my lord. Even if assuming the contention of the petition, APSC, that I have written my roll number wrongly.
and this wrong roll number was in one paper only.
One paper only. Otherwise, my lord.
And it was completely wrong or one of the figures went wrong?
My lord, the roll number, that is also a, my lord, thing, because it is.
Mr. Counsel, you should not have, you're Mr. Das.
I am Das.
Mr. Das, you should not have taken this double plea. That
No,
this
I
number has,
understand.
just a minute, that
I'm
this
sorry.
number has, you have confounded the situation and created problem for yourself. You should have gone before the learned single judge and should have stated that you have appeared in all papers, there was no dispute. There also in GS3 paper also you were there because attendance sheet matches your identity. And then you say that this roll number is in another handwriting, you stoke, what is it called? Hornet's nest. And therefore the judge concludes that perhaps you're a fake student.
My lord.
Somebody else appeared for you and therefore wrote a wrong number. You must have appeared in all papers, but in GS3 you are weak. You had a ghost writer. Why did you say that? You could have said that there was some mistake in writing the number. It was only one figure wrong. You claim that this is not your handwriting at all. Then who filled it up? And in that, if this is the situation, I think if you take alternative plea, many a times you succeed. But here you have spoiled your case. I mean, not you. I mean, that
the council was, my lord.
whoever.
Yes.
So therefore, this
No, this plea was also taken. The plea.
The moment you take an alternative plea, the second plea of yours that it is not your handwriting at all, it is to be taken. Then who wrote it? Did you leave that roll number column completely blank?
That is why, my lord.
Therefore, you should.
That is why, my lord, at the very
Have
beginning.
you understood why I say?
I understand.
You should not have taken that plea ever.
That plea itself is a dicey thing, my lord. That plea that was taken.
Therefore, the court has expressed.
No, what, my lord, the second plea also was taken by the petitioner that, look, I appeared in the GS3 paper. My attendance sheet was there. Attendance sheet was there before the learned single judge. Wherein
Let's see how the single judge has dealt with it.
Yes. The learned single judge may not simply said that there was no manipulation in the.
1 second, it's a
I'm
short
sorry.
order, let me go through.
The relevant portion.
Just a minute.
I'm sorry. I'm sorry.
One roll number has got 6 figures, one roll number has got 7 figures.
2304, okay, no, that is not good.
No, in the second line, it says same para 7 itself, second line on the right side.
230241. 2302.
No, there's.
24, huh? Again, this is wrong. We should not have taken this. Now, they don't say that it has been manipulated. If he took it wrong, who appears for APSC? Now, what do you have to say? There's one figure missing and one figure wrong.
Yes, ma'am.
One figure is missing and one figure is
wrong.
There are other methods of checking, no?
That's true, my lord, but your contention, his contention is that, my lord.
Where is that instruction in the booklet that if the
Yes.
roll number is wrong, it shall be cancelled?
My lord, your lordship, page 118, my lord.
118 of what?
That's appeal, ma'am, appeal, ma'am.
But it doesn't say about the roll. number.
1 second.
I'm sorry, Milord. my
Mr. Das,
apologies.
You have had your say.
My apologies, Milord. I'm sorry.
Yes.
Important instruction, my lord.
Hmm.
That the candidate should read and follow all the instruction carefully. Not following the instruction may entail penalty in the form of deduction of mark, cancellation of the candidature, debarment from the further examination of the engagement. Roll number and other details of the field only by the separate provided by the question to answer sheet booklet. 1.
This is not something. And attendance sheet, you check up, you verify from the photograph, the person.
Yes, my lord.
This you should have considered, no?
Because your lordship.
You have published the result.
My lord, is a comprehensive. My lord,
Huh?
my lord.
You have published the result.
Yeah, already, my lord, appointment were made in 2022 in the result, my lord. 22 now, 2024, my lord. Result.
When did you file the appeal?
Repeat.
When did you file the writ petition?
Writ petition was filed immediately, Milord, after getting the RTI reply. It was in the year.
RTI reply was, when did you seek RTI reply?
Yes, Milord. It was filed on, my lord, April 2024. And
After 2 years.
Milord, the RTI reply.
2 years, Mr. Das.
No, Milord,
result was
result was.
The result was published when?
I'll just.
17 January 2024.
2024. 17 January
was 24.
2024, the results were declared.
All right.
I approached in the month of April. RTI reply I received on 8/3/2024. So it was immediately I will not approach this honorable court.
All appointments made.
All
positions filled.
My lord, even my lord, next exam in also.
You have been very, the commission has been very careless, has been very harsh with this student.
My lord, actually, it's a competitive examination, my lord. If he not been my
Competitive examination, all
No,
right,
my lord.
but this could have been verified.
Yeah.
You can't just, take a shortcut and say that he is not the person. In fact, he committed a mistake
No,
by
I
saying that it is tempered. He
Yes.
should have immediately admitted
He's-
that there was a mistake. Every paper he writes
my lord.
correct roll number.
That is true, my lord. In that
Every
particular,
paper he writes
no, my lord, in instruction, my lord, the instructions are mandatory in nature.
No, instruction, what instruction? That if you enter wrong number, wrong roll number, you shall be
My lord,
debarred.
that is,
You
my
don't
lord,
say that.
what type of, my lord, he is going to be a responsible officer of the government. My lord, in every step, he has to be faced, my lord. He has not been, my lord, cannot carefully retain the number.
You are a responsible officer of the government, he would have become provided you would have allowed him to survive.
My lord,
You have caused
Go
infanticide. Mr. Das, can anything be done? I don't think it can be done.
Lordship will kindly examine.
You miss the bus.
Lordship will kindly examine. Lordship will, if my lord, kindly come to page 107 for a moment. This is the attendance sheet. The irony is that, my lord, Lordship has seen serial number 136, that is the appellant. His roll number is written in the attendance sheet correctly, 2302415. Attendance sheet, it was there. It was in the printed form. Then, my lord, he appeared, his photograph is there. This date is 9/7/2024. 9/7/2023, on which date it is an admitted factual position that he appeared. Now, invigilator to sign after verifying whether all particulars have been filled in by the candidate properly. In my QCA booklet, the invigilator also signed.
How would he know that you have missed out on one figure and you have made a wrong statement? He would not, he would think that the candidate has filled up the column. Therefore, he
Ultimately,
signs it.
after the exam is over, he will have to sort the question booklet, which question booklet is of whose.
Ultimately, this folly would have been checked at some point, no? And therefore you are ousted.
My contention is that, my lord, if there are, because question booklet number is most important.
Theoretically, but from heart, I am with you. You're,
I understand.
You may be a good student. You could have become a good officer.
In fact,
Asset for the.
In fact, my lord, if I may say, only 20 or 30 marks in GS3 paper would have led to my selection because I scored, my lord, 761 marks. And 20-30 marks would have led to my selection.
Reality here is this. Now, Mr. Das, the commission has become functus officio. They can't do anything. The government says, if we question the government will say that we issued a requisition. The commission conducted the examination. Commission returned the result. We have accepted the result and we have issued appointment. There is nothing left for us now.
Milord, my only prayer is that, Milord, my question booklet, the GS3 paper wherein I appeared, that has to be evaluated. That is my humble prayer. Whether I get the appointment or I don't get the appointment, that is another aspect. But you cannot deny evaluation of my question, answer booklet.
That is not your right. Your right is only to the extent that if you fill up every detail correctly, then it should be evaluated. They could not have deducted, they could have deducted marks or they would have otherwise held you irresponsible person and not suitable for the job. That's another thing. But here, the paper of yours could not be correlated to your identity because of the wrong registration.
No, that cannot be, Milord.
We have seen that.
With all due respect, Milord, that cannot be because my identity is relatable also.
Tell us what can be done now.
My lord will consider on
What
merits.
is this? Can we oust somebody else? Now all the positions have been filled.
No, that is not the stand, my lord. That is
We
not
have
the
to ask the government, no.
Lordship.
What would the commission do?
No, the lordship can inquire with the commission or the government that whether there are any posts, my lord, remain. Because in public service, my lord,
That is very difficult. And the vacant post would have been carried over to the next appointment list.
That is also held, my lord.
Lord, my understanding is that if there is wrong, if some, my lord, mistake had happened, if it has to be cured, then, my lord, the cure has to be, my lord, to the, my lord, whatever comes in front, that will not restrain the.
We can pass an order which will have the effect of, the operation successful, patient died.
But my humble prayer before your
I
lordship.
am absolutely upset at this. They should have been more compassionate.
Because when you have the question booklet number, at least.
Mr. Das, I am aware of it because we have taken examination for so many judicial officers. I have conducted the examination and by judicial orders passed by me, many of them have entered service, but then I knew these statistics, no? How many posts vacant, what happened, what did not happen.
Lordship, may I just point out one thing? Lordship may inquire because this petition was pending.
You would have, if you have read R.F. Gupta or R.F. Jain versus State of Bihar, we have laid a good foundation for this kind of service jurisprudence. You need not look at it, but that's a
No, I'll just certainly, my lord.
But we can't give you any benefit. We can only record, but to what avail? And you scored very well in other papers.
Yes, my lord. I scored 761 total in excluding GS3, my lord.
Wow.
That your lordship will find my marks at page.
Difficulty, Mr. Das, no matter how many times I get persuaded to do something, but then this is an appeal. We don't find the order of the London single judge to be bad on any count. Well, and we are not sitting in appeal like a general statutory appeal. Unless the order is absolutely perverse, we would not like to interfere and so
Look, so
forth.
far as the finding.
And then the end result, you don't get anything. We are unhappy. Nonetheless, we can't help it.
My lord, so far as
Mr. Das, learned advocate for the appellant, and Mr. T.J. Mahanta, T.J. Mahanta, learned senior advocate for the Assam Public Service Commission. The appellant questions the judgment dated 11/2/2025, passed by a learned single judge of this court in, what is this number? In WPC number 2053 of 2024. Whereby the prayer made on behalf of the appellant for consideration of his case by the commission, by the Assam Public Service Commission and the government was rejected. First off, on the requisition by the government for holding competitive examination, the commission had held the examination in which the appellant had participated and had passed the screening preliminary examination. Stop. He appeared in all the 6 papers in the mains examination. However, unfortunately, in one of the papers, bracket General Studies number 3, he inadvertently entered wrong roll number. This led to the cancellation of his entire candidature, which he could detect only when he did not find his name in the list of successful candidates, and thereafter through an RTI inquiry. On perusal of his QCA QCA answer booklet, the appellant had found that a wrong roll number was entered there, but it was not in his handwriting. This was but an alternative prayer. The first contention of the appellant was that there was no dispute that he had not appeared in the examination, in the concerned examination, which could have been verified from the attendance sheet. Later, the invigilator also had signed the QCA booklet. There could have been no dispute about the appellant having appeared in the examination, as in all other 5 papers, fortunately, correct roll number was entered in the column meant for it. This was more than cogent. This was more than a very strong evidence of the appellant having appeared in all the papers in the mains examination. The commission, Mr. Das argues, would have done better in the interest of the candidates in general and the appellant in particular, of having verified that the wrong entry of the roll number could be inadvertent or in a state of nervous frenzy of a student while appearing in a competitive examination. One number from the correct, one figure was missing. One figure in the roll number entered by the appellant in the concerned question paper, in the concerned QCA answer book, one figure was missing, whereas the other figure was wrong. It appears that the appellant had before the writ court taken a contradictory plea that the roll number was entered by somebody else, as it was not in his handwriting. This could not have been the case for the reason that there was no tempering or manipulation semicolon, just that the wrong roll number was entered with one figure wrongly stated and one figure missing. Stop. The learned single judge, however, found that according to the instructions issued to the candidates, wrong roll number would not have established the identity of the candidate with the appellant. And therefore, in either case of inadvertence or tampering / manipulation, the candidature of the appellant had become suspect. Very strenuous efforts were made by Mr. Das learned counsel to convince that there was no manipulation. To convince that the identity of the appellant as a candidate in the examination could have been easily established with his handwriting in the answer sheet, in the concerned QCA answer book, and in the 5 papers in which he had appeared. Apart from that, his signature on the attendance sheet before he entered the examination hall was also a proof of the fact that there was no ghost writer employed by him. We do find some substance in the submission of Mr. Das, but on a deeper probe, we found that the advertisement was issued in the year 2022 and the results were published in the year 2024. Whereafter, accepting the result published by the commission, the government went ahead and appointed the successful candidates on respective posts. We had at one point of time contemplated, during the course of argument, contemplated to inquire from the government whether any post against the advertisement had remained vacant. But on a second thought, that any vacancy would have been carried over to the next appointment process, which also stands concluded as informed to us by Mr. Mahata. We have no option but to, we are left with no option but to close this appeal. Apart from this, prima facie, apart from this, we do not find any fault line in the judgment of the learned single judge for us to interfere. The thought of giving one more opportunity to the appellant by produce. Yes.
Lord, may I just pray one thing, Lord? Can there be a direction to evaluate my?
That is meaningless, no?
Deeply.
That's meaningless. That if it ends in no result, that's meaningless. Why to ask for that exercise?
Because otherwise,
you had a case, but
otherwise they I am a candidate, they are the commissions. The conscious decision has to be taken.
Item 9, sir.
I am unhappy dismissing your petition, but what to do?
Lord, I am also unhappy. Much obliged.
Item 19.
Wait, please, Lordship. Lordship, item number 32 is also connected, Lordship. If
Item number
Lordship,
32.
32, Lordship.
We'll hear it together.
Lordship, if 32 can be taken up, will be convenient, Lordship.
So in 32, the reply has not been filed.
In this case also, reply has not been filed, Lordship.
We'll hear it. Reply needed or not?
Lordship.
Is reply needed?
No, Lordship.
Item number 32. Yes.
Lordship, I have filed this writ appeal, Lordship.
Louder, you speak on the mic.
Lordship, I have filed this writ appeal, Lordship, challenging the, in a limited extent, challenging the order dated 25/3/2025 passed by the single judge, Lordship. Lordship would find at page number 155. In item number 32, Lordship. Lordship, the case in a nutshell is,
Give us 1 minute.
Lordship.
Page 158, 159.
155.
150?
155, Lordship, the impugned order.
150.
Reading the.
No, 159.
Lordship, I,
159 is the operative portion of the order, I think.
I'm, item number 32, Lordship.
32,
Yes, Lordship.
159.
Yes, Lordship.
Last
159 is operative
How
part.
about the appointment of the writ petition?
Yes, sir. Operative part.
Not very sure.
I think 159.
However, the appointment of the writ petitioner shall not be disturbed in any manner without serving them 60. What else do you want?
Lordship, what is,
What else do you want? In fact, this was also uncalled for.
Lordship, what has happened?
Because this was uncalled for, why do I say so? Now, you required 60 days of notice for terminating your contract. So far, so good. But only because an advertisement was issued for fresh appointment, how was the court sure that within 60 days, the appointment process would be concluded? Therefore, this was uncalled for, but it was in your favor and you have challenged it.
Lordship, may I just, I understand, Lordship, I understand, Lordship. May I just, only thing is that, Lordship, I came before his honorable court challenging the advertisement. My whole entire contention was
You can't do that.
that
You can't challenge the advertisement unless you say that you were not allowed to participate.
no, Lordship, in this case, what has happened, Lordship? The deputy commissioner did not have any power to issue the advertisement. Now, that being so, Lordship, now, Lordship, if your Lordship may kindly appreciate.
That will be questioned by persons who do not get successful, who don't become successful in the appointment process. You did not even apply.
No, Lordship, the advertisement was made on a post which I am already in existence, Lordship. That was my own thing, Lordship.
You are on a contract, you're Mr. Deka.
Lordship.
Mr. Deka, this is a very common business of the government. See, if the appointment process gets delayed, contractual appointments are made, and in the meanwhile, the government agrees and proceeds with the regular appointment process, advertisements are issued, giving liberty to these contractual employees if they have not crossed the age to apply and consider their luck. I mean, what is so unusual about it?
The only thing, Lordship, that 60 days notice, Lordship, was never a part of my pleading, Lordship. That 60 days notice was not called for, Lordship.
That is an
And
additional.
because of that handle given, Lordship, I was given a termination order. I came to this court asking for relief. Rather, I became prejudiced because of an observation, Lordship. That handle was not necessary, Lordship.
In any case, regular appointment. And what happened to that advertisement?
That advertisement is there, Lordship, and we contested the
Process
case.
is concluded.
No, till now not completed, Lordship. The only
In
thing,
fact, so far my instruction is concerned, lots of, we have got the instruction that advertisement has been done, that the process of completion is almost on the verge of completion in a day or two.
And how about this allegation? How about this?
So these
Just a
allegations
minute.
totally.
Allow the court to put question to you.
Yes, also.
If you start answering simultaneously,
No, no.
how would you hear the question? Now, what is your version of the charge of the appellant that the DC was not entitled to issue advertisement?
No, he is appointed by a NGO, NABARD. So that was the contract between the Social Welfare, the Borpata Department and the NABARD. That agreement has already expired in October last year. And after that expiry of that advertisement, new advertisement for appointment has been issued. And apprehending that he may not be a part of it, so he have come across and approached the single judge, and single judge has, as an abundant caution, has given a additional period of 60 days. If at all the agreement is subsisting, then they should be given a fair opportunity of being served with a notice. That is already over. And that was not, even he was given a fair opportunity, but fact remains that their agreement under which he is part of that.
He's saying something else. He's saying something else, Mr. Letkant. He says that he had not come for seeking 60 days accommodation by way of notice.
Right.
He came primarily with the question that this advertisement notice could not have been brought about by the district commissioner, Parapeta. The learned single judge, look at me, don't talk simultaneously. The learned single judge mistook his prayer and said that no, you'll get 60 days notice, don't worry. Now, because of this observation, without any reason, his services were terminated. We could have understood that it was in the regular process of replacing him with a properly appointed Sakhi under Mission Shakti, if termination would have come after the results were published. Therefore, he has a point that this was vindictive because he came to the court, obtained some advantageous order.
And
that's his argument.
Yes, that
Whether
is,
we accept it or not,
yes,
that's
that is his argument. And just to counter to that fact, we have got a specific instructions to the fact that even though the contract has been finished off in the last October, still then those employees have been retained by the district social welfare department for the very reason that till the time the final appointment process is completed, they may be asked to assist. That was an additional assistance being taken from them. And for that, even though the term period of the contract is over, they were engaged.
All right. Both the appeals have been taken up together and are being disposed of by the common judgment. They have heard Mr. P. Decker, learned advocate for the appellants in both the appeals, and Mr. S. Barua for the estate. The challenges to the judgment dated 25/3/2025 passed by a learned single judge of this court in WP number so-and-so, whereby it has been clarified that till the appointment of regular Sakhis under Mission Shakti.
There is nothing called regular lottery. This is temporary only.
Temporary contract.
No, I'm saying something else. I'm saying something else. No, just read out the order. I'm saying something else. Till the appointment of regular employees, the appellants shall not be disturbed in any manner without serving them 60 days prior notice as per the terms and conditions of the contract, if they would be still functioning as Sakhi one-stop center in the district of Barapeta. It appears that the appellants / writ petitioners were working on contract as Sakhi one-stop center since 2019, and their contractual period was being extended from time to time. Stop. During the continuance of such contractual tenure of the appellants, an advertisement notice was issued on 4/3/2025, raising apprehensions in the minds of the appellants that perhaps they would be replaced by regularly appointed Sakhis. This advertisement notice was perceived by the appellants as an attempt to substitute them. The appellants actually, it has been argued, had approached the writ court challenging the validity of the advertisement notice on the ground that it was issued by District Commissioner Barapeta, who had no authority to initiate the process of appointment of Sakhis, because such an appointment was under a mission for which the authority was not the District Commissioner. The contention on behalf of the appellants is that the prayer was misinterpreted, their prayer was misunderstood and was considered in the context of an attempt by the writ petitioners / appellants, the appellants / writ petitioners, to save their appointment for about 60 days at least, the period of notice before termination of their contract. Stop. In any view of the matter, the appellants / writ petitioners cannot claim any permanence on the post when it is absolutely contractual under a scheme run by an NGO with the support of the government. The period of the continuance of the contractual tenure is no guarantee for perpetuating extension, for extensions being perpetuated indefinitely. It is only in the fitness of things that an attempt was made to appoint regular employees for the work which was hitherto being conducted by the appellants. Stop. There does not appear to be any proscription on the appellants of having participated in such participated in the process against such advertisement notice if they fulfilled other conditions. Stop. Under such circumstances, any challenge by them was not sustainable. The grievance of the appellants today is that because of such an order passed by the learned single judge of the necessity of serving 60 days notice to the appellants, their termination was hurried. Their termination, their contractual tenure was hurriedly terminated. This perception has no basis. This perception of the appellants has no basis. We have been informed by Mr. Barua, learned advocate for the respondent, that the recruitment process is almost on the verge of completion. And despite termination of the contractual tenure of the appellants, they have been retained by the government to perform the task till the time regular employees take charge. Needless to say, for the work rendered by them, they shall be paid. However, we do not find any reason to interfere or interfere with the judgments in the two appeals.
Lordship,
To
that is not a
interfere with the
judgment. It's a-
common judgment in the two appeals.
That is an interim order. The writ petition is still pending, Lordship. The writ petition is still pending, Lordship.
We close the writ petition also. That we can do. We have the authority sitting in appeal.
No,
We
Lordship-
close the writ petition also. Unnecessary, no? You want to go there?
Lordship, Lordship, because I have already challenged the termination orders there, Lordship, before the writ court also, Lordship. So that writ petition.
We will listen. Writ petition shall remain. Kalika? With the interim observations of the learned single judge. We thus close this appeal, leaving it open for the appellants to appear before the learned single judge
And
to pursue their writ petition.
An observation passed before this honorable court may not influence the single judge there, Lordship, because
You don't-
observations were made, Lordship.
Then we have said that you said that it was misinterpreted. The single judge.
Lordship, may kindly.
We can't help it now. Now allow us to close the petition. Or we will strike off, all our efforts would be gone.
No,
We
Lordship.
will strike off, you withdraw this appeal.
No, no, we'll.
But we can't do anything else.
We'll withdraw this appeal, Lordship.
Better. Let them.
It'll be
But
better,
what about the lung power wasted?
Lordship, I would leave, Lordship, I
After
will.
some arguments, Mr. After some arguments, Mr. Deka, learned counsel for the appellants, seek permission to withdraw this appeal, reserving the liberty to them to contest the writ petition which is pending consequently. Acceding to the request of the learned counsel, acceding to the request of Mr. Deka, the prayer is allowed, the appeal is dismissed as withdrawn. With the liberty of force. Unnecessary, you argued, we also got in that mold.
Item 20.
Wait,
Yes.
Your Lordship. Although before I start, the relief which we had prayed in the writ petition has been granted by the authorities. So otherwise nothing remains. Howsoever, an observation by the Honorable Single Judge, but this has happened after the Honorable was passed, so therefore I could not place on record. However, an observation by the Honorable Single Judge that we had no locus to present the writ petition is all what remains, nothing more. That's why.
I don't think so. Let's see the observation.
Page 56. My lord finds that page 58.
Please bear in mind that if no grievance remains on record.
Absolutely, that's what I said, nothing remains on.
Therefore,
I just placed it.
leave that aside.
Yes.
That would be considered as an en passant observation.
That's okay.
Which will not come in your way in any proceeding.
Only that much.
But we will not say that, no.
I understand.
We will not say
Therefore, I
that.
apprise Honorable
You
Court.
withdraw this.
Lordship.
Can I have your name, please?
S. Banik.
S. Banik. S. Banik. B-A-N-I-K.
Mr. S. Panik,
No.
learned advocate. After some arguments, senior advocate seeks permission to withdraw this appeal as the grievance of the appellant has already been dismissed as having become infractious.
Lordship.
We'll come after 5 minutes. We'll get back after 5 minutes.
Yes, yes.
Item 21.
By please, your lordships, my lord, the appellant, present appellant is a my lord, board, Assam State School Education Board conducting examination of matriculation and also higher secondary examination. And now my lord, respondent number 1, and this is a junior college. I am the appellant, my lord. I am not the appellant, my lord. Board. We are conducting the examination and our respondent number 1 They are the school, non-government school, my lord. They are conducting examination and they are the affiliation with us. We given the permission to open so and so, so and so. What happened, my lord? I mean, the nutshell of the background, they have filed 2 writ petition against one order. Influence order, I will come later on. Background is what happened. My first writ petition was moved, they brought in 16th June. In the writ petition, my lord, they did not address properly. They returned to the Chief Justice as a, my lord, those who have already elevated and joined in the Supreme Court. He is no more in the High Court Chief Justice. In the meantime, 30th May 2025.
Those stories may not be relevant.
No, but irrelevant. Irrelevant is why relevant. I am saying that writ petition is vexatious. How vexatious? First of all, they wrongly addressed to the Chief Justice.
Appeal, no, sir. So let us see what is the order. Do the order.
Yes,
usually.
definitely, my lord. Definitely, my lord. No, now, still now, they are doing wrong.
The legend and the background.
The background is necessary because they are.
Be understandable only if we see the judgment in appeal.
Yes, that is. But why I am mentioning, my lord?
Hear you.
Yeah.
Mr. Chudia, don't think that I am going to gag any lawyer. We will give you all time to argue. But I would only request you to go in the way in which I want you to go.
Yes, sir.
Come to the tuned order.
It's one. The first of all, Lordship, kindly see page 81.
No. First, the order.
Order, challenge, Lordship, kindly see 113. 113
What is this order dated 27/6/2005.
3703/2025. NCT Senior College versus so and so, so and so. And Lordship, kindly see.
Just a minute, Mr. How are you offended by this order?
Yes, because my lord, we have suspended temporarily the affiliation of the petitioner's school. Now they cannot take admission in the new students, my lord. But this order, the impugned order in the petition, my lord, Lordship, may I read it, my lord? It has not affect the existing student. It has not affected the student, my lord. We cannot implement because they have opened the answer books, my lord. When the subject mathematics was scheduled to be held on a March,
All right.
they open it.
That's all right, Mr. Chukia.
They open it.
Think of this. They may have done anything. But were they required to be given a notice? And
No.
your argument before the writ court that they are not required because the regulation does not say so is not acceptable as on date.
I will show you the regulation, my lord. I will show.
No. You may be right that there is no special provision in the regulation for giving a hearing. But you can't see the basic principle of audi alteram partem. Can you do away with it? Only by saying that a regulation does not prescribe such mode. You are passing an order suspending the affiliation of a school. All right. you will at least give him 24 hours notice, 48 hours notice. And the reason, this is the reason you have tampered with the mathematics paper. And therefore we don't have trust in you. You don't admit students. Good. Let him answer. Decide the same thing.
That is correct, my lord. That's why, my lord, we are, for a time being, we suspend it. Then after we will issue notice, my lord, to them. You show cause. Why is your,
So therefore,
your application should not be cancelled. That is later on. The suspension, in any case, my lord, suspension, there is no prior notice is necessary. This suspension only.
Is agreed with this, with to page 10. The reason.
you to page 10.
Page 10. Is the number for the appeal. The pensions are the report.
Yes, yes.
That is only, that is the nothing else. What is raising is not here.
Mr. Patia, my brother has rightly pointed out, you're raising an issue which we do not take into account at all. Now, what you're arguing is different from your pleadings. We accept your arguments, but it has rightly been pointed out by my brother. You are talking about, the formalities of addressing.
That is the other chapter, my lord. Why I am pointing out.
We don't enter into
That
such.
is forget it. Forget it, my lord. Now the main question
Now,
is the dispute order.
If you want any interference by this court, argue the merits and not these trivialities.
My lord, I may be hard, my lord, because when we issue the suspension order,
That's
it
right.
is not a punishment.
We understand that.
Yes.
Therefore, you can argue this. Let me formulate your points in your favor. Now, you say that the learned single judge should not have stayed the suspension of the affiliation for the reason that they would start admitting students, and ultimately, if the affiliation is cancelled, what will happen to the students? And therefore, this order is bad.
Yes, thereafter, after issuing suspension order, we will definitely, we
So,
issue.
Chutia, we have formulated the ground for you. Still, you are insist going here and there.
No, my lord, no, we will follow it. Why not, my lord? Suspension is merely temporary. We suspend it. After that, we will issue notice. Why your application should not be cancelled?
Surprised that I am arguing for you. Still, you are arguing.
No, my lord, we are, because my lord, they are at entered school, my lord, they are opening the question paper and distribute it to the students, my lord. What is the sanctity of examination?
Perhaps I have not been understood by you. What did I tell you? I said that agreed you did not give a notice. You initially suspended the affiliation, and then you will issue notice for final, decision whether to keep the institution affiliated or not. So
Then Lord,
here the judge.
Yes, there is lordship dispose of the writ appeal, my lord, with a direction there, my lord, setting aside the impugnance order. I have no authority and to take steps afresh following due process of law.
I was going beyond that.
No, lordship, there is stay order is there. The impugnance order is stayed in the writ petition.
We were contemplating of lifting this stay order. What are you talking, Mr.
No, my lord. Otherwise, my lord, otherwise the way the order is stay, how I can, my lord, issue notice now? We will have to issue notice. The stay order is there. We cannot issue notice now.
If you don't want to understand, we will not force it down your head. Yeah, we close this petition by saying that we set aside this order, you issue notice and do whatever. You're required to do this. I mean, we were suggesting something else for the benefit of students. Why are you not understanding?
No, my lord, the students.
All right, conceded. Whatever you want, we'll do.
So actually, the students are not affected. They are allowed.
They are allowed. So therefore, we set it aside.
No, they are allowed to continue examination and going on manner study. But new student cannot they take admission in this school because they have opened the question paper. They are doing an offense, my lord.
But this suppose during the period that you will give notice to the school and they will respond, the school will continue taking admissions.
So taking admission, my lord, if the affiliation is, my lord, ultimately cancelled, ultimately cancelled after giving due notice, then what happened to the school, my lord?
This is what This is
It's a private school, my lord. No, that is the whole problem, my lord. In the item number, my lord, 8 or 9, that was the
I'm
problem.
very sure that Mr. Chutia, you have not understood what I am saying.
No, but I understood, my lord. My question is only because.
Your question comes later. We have flagged that, I mean, the necessity of interfering with this order, you are not accepting it. Anyway, do whatever. Take it.
My lords, may I have your lordship's permission to address your lordships with the virtual mode? I am Parthiv Goswami appearing for respondent number 1.
Respond number 1, yes.
For the college, my lords.
Hmm.
My lords, it's an interlocutory order which has been put to challenge in the writ appeal. After hearing both sides at length, my lords, as it's evident from the order, the learned judge has struck a balance by staying the two effects of the order. The affiliation is suspended, and also we were debarred from taking fresh admission.
You're Mr. Parthiv Goswami.
Goswami, my lords.
Mr. Goswami, we are only making the interim order passed by the learned single judge absolute.
I thought otherwise, my lords. I'm sorry, my lords. I'm sorry, my
Don't
lords.
argue any further. All.
I'm sorry.
I interpret the same pair, my lord. That's why we are putting this.
A school run under the name of NCG Senior Secondary School, Dhemaji. The affiliation of a school run under the name and style of NCG Senior Secondary School, Dhemaji, was suspended by the Assam School Education Board on the ground, was suspended. Which was challenged by the school before this court, before a learned single judge, by WPC 3703 of 2025. The learned single judge, after appreciating the arguments on behalf of the concerned school, that no notice was given to the school to explain its cause before suspending the affiliation, passed an interim order of putting in abeyance the order of suspension of affiliation of the school and made it subject to the outcome of the petition. The arguments advanced on behalf of the Assam board, Assam School Education Board, before the single judge was that the regulation in that regard never contemplated of issuing any notice before suspending the affiliation. Additionally, an argument was made before this court on behalf of the board that suspension was the initial step. Suspension of the affiliation was the initial step taken by the Assam board. Whereafter, notices would have been issued with reasons for suspension to the school for it to respond. We are of the view that before suspending the affiliation of the school with the board, the school ought to have been made known the reasons for suspension and should have been permitted to show cause as to why any punitive action was not required. For the aforementioned reasons, we as an we therefore find it more appropriate to set aside the entire order dated 27/6/2025, even when the writ petition has been kept pending, so as to enable the Assam Board to issue requisite notice to the concerned school, citing reasons for the decision to suspend and ultimately disaffiliate the school, giving reasonable opportunity to the school to explain its call. The board shall take a final decision only after considering the reply by the school. With the aforementioned directions, the appeal stands disposed.
Obliged.
Deeply obliged, my lords.
Item 22.
Specifically, respond.
We have closed the petition.
Your lordship has set aside the impugned order.
And the writ petition as well. The entire case has been closed.
Because, my lords, the impugned order has been set aside. Deeply obliged, my lord. Deeply.
But we have not meeting, we have a meeting now. Can't get out of the system. If it spills over, it comes the next day.
Yes, you know, then they will take the.
We might get up, I'm not sitting. Yes, call out this.
22.
Yes.
Item 22.
Lordship, this writ petition has been prepared by the Union of India, Lordship.
Yes.
We are assailing the order passed by the land tribunal, by which the tribunal allowed the OA directing for a promotion, giving notional benefit of promotion to the IFS to the respondent. Now, Lordship, I found that there is one principal ground of challenge, Lordship. What happened in virtue of the direction of the tribunal, Lordship, there was a review DPC, and that finding has not been challenged in the OA. That Lordship will find at page 140.
No, let's see the first impugned.
That was of 23, relying on the recommendation of 22.
1 second, sir.
Comply for the full economy.
Huh? Comply
for the
already. Permission for it is
when listed issue police partially comply for it.
Lordship, my friend is saying that order has been partially complied with.
In the
Let me take
meanwhile-
instruction to that, Lordship.
Mr. Chakravarti, let it CGC seek some time to take fresh instructions in the matter before addressing the court. Re-notify. 1 week? 1 week?
1/8.
All other matters will spill over according to the practice here. This court will not resume after lunch.